My diaspora clients sometimes have a challenge with that. You have to sign and I have to pay first. I'm like, yes, it's actually a condition precedent. That's what that special condition wants. That says it's a condition precedent that before the agreement is considered valid, both parties have to sign and the deposit paid. Step 2, vendor's attorney uses deposit to pay the stamp duty and transfer tax and submits the transfer for what we call cross-stamping at a later date, generally when we know that you are able to finance the balance of the purchase price. So the stamp office is the friend of the lawyer because we send it down first to be assessed. Generally, we know that it's going to be 2% of the value of the property that is going to be paid, but you can find yourself in a position where you're getting a deal, but the property is worth more. And so depending on what the terms of the agreement says, the vendor can actually come back to you and say, you know what, I don't want to proceed because I'm not going to pay this extra transfer tax. But depending on the wording of your agreement for sale, which is why it's so important to have a lawyer, it could have that you would advance that difference and it be treated toward the purchase money so that the sale wouldn't be aborted. So the fees would be paid all out of the deposit and you would proceed. Now, this is the more tricky part. Mortgage finance purchaser where vendor has no mortgage on title. So the purchaser gets their letter of undertaking from the financial institution generally within the 60 days. Then the vendor's attorney gets all the property tax things squared away, generally by showing a property tax certificate. There's generally have to be proof of water bill and then all of the things that we need to send to the purchaser's lending institution to include the duplicate certificate of title. There's a reason why we call it duplicate certificate of title. It means that there is one at the National Land Agency and you have the other one to it. So duplicate doesn't mean copy in this case. A duplicate certificate of title is an original title. It's just the one that is in your hand versus the one that is on the register at the National Land Agency. Then the purchaser's lending institution is going to lodge the transfer document and title at the same time they're registering their mortgage. Once this is completed, the mortgage institution will then send the sum that they promised and guaranteed they would send in the letter of undertaking. And so what we have is a system where your attorney is a stakeholder. We want to make sure that he who has the title doesn't have the money.